Good afternoon, everybody. It's 12:30, so I'm going to get started. Firstly, I hope that everyone is doing well today. I'm Katie Jacobs from the CIPD, and I've been chairing our coronavirus series of webinars. And this afternoon, we are returning to an old favourite topic, furlough. It's back, specifically last week's confirmation about the extension of and changes to the government's coronavirus job retention scheme. So joining us this afternoon to discuss this topic and to answer your questions, got a fabulous panel. We've got Ben Willmott, Head of Public Policy at the CIPD, Andrew Willis, Head of Legal and Advisory at HR Inform, the CIPD's Employment Law Resource, and Tom Blake, Managing Director and Executive Coach at Blake Connolly Limited. Thank you so much, everyone, for joining us today. As ever, I'm just going to run through some quick housekeeping notes before we get into the content. First up, this session is being recorded. It's going to be available on demand via the webinar section of the CIPD website, and you'll be able to access it from this afternoon. You'll also be able to access the slides, and you can get hold of recordings of all of our previous webinars there, as well as sign up for future sessions. Secondly, on questions, and we really want to take as many questions as we can during the webinar, could I ask you to please use the Q&A tab, which you should be able to see at the bottom of your screen. Please don't use the chat box for questions, use the Q&A box instead. Just to flag that for legal advice, CIPD members can call our HR Inform helpline. It's available 24/7 and you will get an individual response. And a reminder that we're updating the FAQs and the resources on our website all of the time as new information becomes available. Head to the CIPD Coronavirus Hub for more. And I also want to flag our new wellbeing helpline for members in the UK and Ireland. With award-winning workplace wellbeing provider Health Assured, we're now providing CIPD members with free help and support via sessions with qualified therapists. It's so important that we look after ourselves in times of stress and change. And finally, I just want to flag that you have a few more days to sign up to attend the Festival of Work, which has gone digital and is absolutely free for members. The deadline for that is this Friday, the 5th of June. So do sign up if you haven't done so already. So let's get on to the content. As of the 24th of May, there were approximately 8.4 million workers covered by the government's coronavirus job retention scheme. That means that more than 1/4 of the entire UK workforce is currently furloughed, and it totals £15 billion worth of claims. Just mind-blowing stats. At the end of last week, the Chancellor confirmed what the next steps will be for the extension of the scheme, including enabling the introduction of part-time furloughing or flexible furloughing. While we don't have all the answers yet, further guidance about how this all will work in practice is expected on the 12th of June. So today we're going to go through the changes to the scheme and we'll explore what the next steps people, professionals should be taking are, and then we'll probably have to revisit once we've got that guidance. We're going to hear from Ben and then Andrew and then Tom, and then we'll take your questions. We've had quite a few in advance, so I'll try to get through those as well. And as I said, we might not be able to answer all of the questions as we simply don't know yet, but we will make it clear where we are awaiting further information to clear things up. So that's it from me for now. I'm going to hand over to Ben, who's going to give an overview of changes to the scheme. A reminder, you need to unmute yourself, Ben. Ben, you need to take yourself off mute.
Sorry about that. Good afternoon, everybody. As Katie said, the government announced on Friday its plans for making the furlough scheme more flexible and gradually increasing employer contributions towards its cost from 1st of July until it closes at the end of October. CIPD is particularly pleased that from 1st of July, it will be possible for furloughed staff to work reduced hours where possible over the last 4 months of the scheme. And this is something we've lobbied the Treasury strongly on, so we really welcome this change, and we think it will help employers to bring staff back gradually as lockdown measures are reduced and as the economy hopefully starts to recover. There is no magic formula for how to remove the support to employers provided by the job retention scheme without causing significant redundancies. However, hopefully the plans announced by the Chancellor will give organisations significant breathing space while lockdown measures are unwound to protect as many jobs as possible. Now, we're not quite sure what happens from November in terms of any other support schemes. There's quite a lot of discussion about particular sectors like leisure or hospitality that might need further support. But I think if there is further support, it will be through separate schemes, but we'll have to wait and see what happens, I think. I just want to give an overview of the key changes to the scheme before handing over to Andrew and Tom, who will pick up the detail from a legal and employer practice perspective. So in June, the scheme will close to new entrants on 30th of June. The final date by which an employer can furlough an employee for the first time will be on the 10th of June. As I said before, from 1st of July, employers can start bringing furloughed staff back to work gradually on reduced hours. And then in August, employers are being asked to start picking up some of the cost of the scheme. In August, it'll only be in the form of employers paying national insurance and pension contributions. But then in September, government will reduce its level of wage subsidy from 80% to 70% of furloughed staff wages. So employers will be asked to pay 10% of wages. And then in October, the government subsidy reduces again to 60% of furloughed staff wages, and employers will have to pay the balance of 20% of wages to make up the 80% total up to the cap of £2,500. So that's the sort of changes to the scheme in outline. As I said, Andrew and Tom will now go through some of the detail. I'm happy to pick up any questions in the Q&A later.
Thanks very much, Ben. I'm going to hand over to Andrew now, who's going to go through that in a little bit more detail from an employment law perspective. Thank you, Andrew, and remember to unmute yourself.
Thanks, Katie. Yeah. If we could move over to the first slide then, please. Thank you. I'm going to just look at the Treasury Direction first, because you'll remember the Treasury Direction is basically the legislation that underpins this furlough scheme. And when it was first published, I think back in April or certainly early May, it caused a fair amount of consternation because in some respects it contradicted the guidance that everyone had been working to up until that point. So a second version of this Treasury Direction has now been issued. So it's worth just mentioning that before we go on to look at some of the particular aspects of the furlough scheme that we know about in terms of flexible furlough. And then I'll close by looking at collective consultation for redundancy, which may well sadly be an option for some of you when considering people bringing people back from furlough. So the Treasury Direction first. The first direction, as I say, and I think it was probably late April, early May, it was published, continues to apply to claims submitted before the 22nd of May, which are not compliant with the second direction. And the second direction was issued on the 22nd of May, and it amends and effectively replaces the first direction in respect of claims made on or after that date, or in relation to earlier claims that would have been compliant with it in any event. Now that's a very long-handed way of saying that basically look to the second direction first. And if you comply with that, you've got no further issue. However, if you don't comply with that, you can look back to the first if your claim was made before the 22nd of May. Now, I think in practice, because the second Treasury Direction is more generous in its provisions and is more consistent with the guidance, it's very unlikely that anybody will need to look back to the first direction. But I think the reason the government have allowed this option is because they were criticised to a degree when the guidance was updated and the date as to qualification for furlough was moved, because in doing that change, in making that change, the government also introduced a requirement that employees had to have been the subject of a real-time information submission to qualify as well. And the effect of that was to actually take people out of the scheme in some cases who had been within the scheme before. So I think the reason that the option is there to go back to the first direction is to deal with that criticism. But I think in practice, I think nearly everybody will be looking to the second direction, and that will give them the information they need. And I've picked out two provisions which are particularly helpful and reassuring to us all in the second Treasury direction, and they're on the next slide. So if we just move over the next slide, thank you. So the first change concerns directors and what furlough directors can do. So the rules on what a furlough director can do have been refined. So previously, according to direction, the first direction, all a director could do was file company accounts or provide information to an administrator. In other words, the duties that could be carried out were very, very restrictive indeed. But in the second direction, which, as I say, can now apply to all claims if necessary, he or she can also make a claim under the job retention scheme and or make a payment of salary or wages. So the scope of what directors can do is broadened out to cover day-to-day management of salary payment and claims under the scheme. So that's very helpful indeed. And the second change that's particularly helpful is what an agreement with an employee looks like. You'll recall that the guidance only ever required employees to evidence in writing themselves an agreement with employees to be furloughed. There was never a requirement in the guidance for employees to put anything in writing confirming their agreement. The direction then came out and threw a cat amongst the pigeons because it seemed to suggest that actually employees needed to respond in writing to an offer of furlough or a request to furlough and confirm their agreement to it in writing, which nearly nobody had done up until that point. Helpfully, the second direction now removes that requirement. So now the agreement to furlough needs to do the following. It needs to set out the main terms and conditions upon which the employer will cease all work in relation to their employment. And really, in practice, that's basically meant stop work, and in many cases, it's also meant agree to a reduction in salary to 80% of your normal. Really, they're the main terms, and if you've recorded those in writing to your employee, then that should suffice and that should comply with that first requirement. It should also ensure that the second requirement is satisfied as well, that this change or these changes be incorporated into the employee's contract. And finally, yes, it's still necessary to confirm agreement in writing, but only from employer to employee. There's no need for any response in writing from the employer themselves. So again, broadly speaking, that brings the direction, the legislation governing this scheme into line with the guidance and should ensure that no one's tripped up by that. So moving on from the direction and onto the new furlough, flexible furlough scheme. As has already been mentioned, we still await further details on how this will operate, and they're due on the 12th of June. And we do need some clarity around certain issues. One of them is whether rotation can continue. The way the fact sheet is worded clearly suggests that people who have been previously furloughed can be brought back onto furlough for the purposes of the flexible scheme. So as long as somebody's been furloughed for at least 3 weeks prior to the 30th of June, there's absolutely no requirement that they be furloughed on that date. As long as they've been previously furloughed, the wording suggests they can be brought back onto flexible furlough. However, we could do with some clarity around whether from there on they can rotate on and off furlough, because that isn't clear yet. Back to the agreement and what's needed in an agreement. Placing employers on flexible furlough will almost certainly require a new agreement. As you all know, a requirement of the scheme, its original form, was that employees did no work at all. And that was nearly always and should have been the subject of a written record between employer and employee. That will obviously need to change now if you're going to ask employees to come back even on a part-time basis. So you will need a new agreement setting out that employees can be required to work during furlough, and also setting out the circumstances in which the employer can require this. So we will need to revisit furlough letters undoubtedly when we've got a little bit more detail on this scheme, and issue new letters to employees as we bring them back into the flexible version of the scheme. Next slide, please. It's also just running through claim periods, because one or two things have changed in regard to claim periods as well. Firstly, it's worth just mentioning that the deadline for employees to claim under the scheme for the period of the 30th of June, in other words, under the current iteration of the scheme, is 31st of July. From the 1st of July, you will no longer be able to claim for periods which overlap months. And the reason is that, as we've already seen from Ben's slide, the terms of this scheme will start to change month to month from the 1st of July. So your claim periods will have to be limited to one calendar month. You won't be able to claim, for example, for part of July and for part of August in one claim. Employers can still furlough different groups and different numbers of employees at different times, but it's been clarified that going forward, an employer can only make one claim during a claim period for each PAYE scheme that they run. So you can only claim for one period of time once. So do ensure that all of your employees are on that claim. And the minimum claim period going forward will be 1 week. You can claim for longer if you want to, up to, as I've said, the calendar month, but you must claim for a minimum period of 1 week. Now, that's not the same as the minimum period of furlough, which, as we know, has been 3 weeks up to now, and we see no reason to think that will change, although it may change when the new guidance is issued on the 12th of June. But nothing said about that to date, but something has been said about the minimum claim period, which must now be 1 week. So they're the points I wanted to pick up on furlough. And my last couple of slides are on collective redundancy consultation, because sadly, given we've got a deadline next week of the 10th of June for placing new employees on furlough, this may be the time when decisions have to be made about redundancy, if not already. So it's worth just mentioning the need to collectively consult in certain circumstances. And as I'm sure you all know, where an employer proposes to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, then the employer must consult on that proposal with employee reps, and they must also notify the Secretary of State at Bays by submission of an HR1 form as well. So those obligations kick in where those three requirements are satisfied: 20 or more employees at one establishment within a period of 90 days or less. And the periods of consultation must either be for at least 30 days if 20 or more employers are going to be affected within the 90-day period, or for at least 45 days if 100 or more employers are going to be affected. Consultation can't really begin until reps are in place. So one issue at the moment, of course, is getting those reps elected if needs be. Obviously, if you're unionised and you have union reps in place, or if you have a works committee or standing employee reps who can handle and deal with this kind of consultation, that's fine. But where you don't, you will need to elect employee representatives. And that can be a difficult process, given that many of your workers may still be either furloughed or working from home. So probably you will need to allow more time for those preliminary steps before beginning consultation proper, and before that either 30-day or 45-day clock starts to tick. Worth reminding ourselves as well that the maximum sanction for breaching collective consultation obligations is a protective award, and the cap on that is still 90 days gross pay, even though the maximum period of consultation is now down to 45 days. So you can see across a big enough workforce, a protective award can be a very, very expensive award to have to deal with. So worth taking advice and getting things right if you're faced with this situation. Next slide, please. And what I've done on this final slide is I've just picked out a couple of particular issues that are relevant in the current circumstances in the context of collective redundancy. So firstly, as well as considering redundancies, you may be considering negotiating or renegotiating terms and conditions with other employees as part of managing the challenges presented by the COVID crisis. And of course, one option when you're negotiating terms and conditions is to dismiss and re-engage. I always think of it as the nuclear option. It's always very much the final step, and it's important to do it very, very carefully, because a dismissal and re-engagement in those circumstances is still a dismissal for unfair dismissal purposes. So very, very important to act fairly and reasonably and be clear on your reasons for doing that, taking that course, and ensure that you follow the formalities that you need to follow. The important thing, though, in the context of collective redundancy consultation is that a dismissal like that qualifies as a redundancy dismissal in terms of triggering collective consultation requirements. So it will count towards the 20 or the 100 dismissals for those purposes. The reason is that the dismissals are for a reason not related to the individual, and therefore they fall within the wider definition of dismissal for redundancy in the context of collective consultation, whereas they wouldn't count as a redundancy dismissal for the purposes of unfair dismissal law. So just be aware of that. If you're renegotiating terms, collectively consult with those employees as well to put yourself in the best position to defeat any protective award claim later. And something we've touched on before, when pooling and selecting for redundancy, be careful not to rely on previous furlough decisions. Those decisions may well have been taken in a hurry. They probably won't reflect business needs going forward, firstly, but secondly, caring responsibilities or underlying health conditions may well have played a part in those decisions, and you don't want those factors influencing redundancy decisions because they could introduce a discrimination risk that wouldn't otherwise be there. So they're the points I wanted to pick up on collective consultation, and obviously we can deal with anything further during questions.
Ian, thank you. Oh, God, what went there? That with you. That's weird. I'm going to hand over to Tom. I'll put myself on mute while whatever's going on there. Tom, over to you.
Thanks, Katie. Hi, everybody. I am Tom Blake. I'm the Managing Director of Blake Connolly. I'm also an Executive Coach at Blake Connolly. We are supporting organisations, particularly from an organisational design and development perspective, and furlough has been a big part of our conversations. So what I'm going to try and do is take effectively what Ben and Andrew said and try and make it real. So if we could move on a slide, thank you. Right, so if you think about your workforce at the moment, broadly your workforce are going to fall into one of three categories. They're either furloughed at the moment, they have been furloughed and they now might be back, and you might have furloughed them again and brought them back and done a bit of backwards and forwards with them, or you might still have some employees who have not been furloughed. Some organisations might have a little bit more complexity, but if we think of our employees in one of these three buckets for ease, and that is of today. So today being the 2nd of June, you've got three groups of employees. If I could move on to the next slide, two of these groups, which is the ones who have been furloughed and the ones who have been furloughed, sorry, the ones who are furloughed currently and the ones who have been furloughed, are now eligible for the new flexible furlough scheme. So they can become a purple employee. As of today's date, the orange employees, the ones who have not yet been furloughed, cannot be part of the flexible furlough scheme. So 2 groups of your workforce they automatically are now eligible, so ticking the box for them. And you've got 1 group of employees who are not yet eligible. So we can move on to the next slide. The question becomes, how can you make them eligible? So to be eligible for the flexible furlough scheme, an employee has to have been part of a furlough claim running up to the 30th of June. So they have to have been on furlough for 3 weeks. So the last date to actually start a period of furlough is going to be the 10th of June. And this is specific to this group of people because they are not yet eligible to join the flexible furlough scheme, whereas individuals you've had out on furlough and brought back are automatically included. So if we could move on a slide. What does flexible furlough actually mean? What can we do from the 1st of July? So the government, as we know, has been a bit light on details so far because the Chancellor just set out his announcement on Friday. Both Ben and Andrew have already mentioned we are waiting for more detail on the 12th, but we can start thinking about the words that the Chancellor used. He talked about working flexibly. He also talked about giving employers the most amount of flexibility. So there is a question, and Andrew has raised the question, I think Ben has as well, is can you start rotating people on furlough? I think you can. So this is a personal view, and we are waiting. It does come with a bit of a health warning because we are waiting for detail, but let me take you through my thinking. So I'm saying that an employer can determine how many days to work each week. And the Chancellor in his speech referenced, an employee could work for 2 days and be on furlough for 3 days. So the thinking is clearly that there is flexibility built into this system. Yes, we need the detail, we need the written word, but as an employer, we need to start thinking about this now and then we can just confirm our thinking when the guidance is published. What that then gives you is a complexity around what you are paying people, because you're going to end up having days where the employer pays a normal rate on a working day and days of work where there is no work, so they are furloughed, so the employee receives the furlough rate of pay. So there's going to be a level of complexity that starts to come through to make sure that you're giving people the right salary or furlough on the day that they're doing something. So we can move forward a slide. And Ben started off with this. I'm a highly visual person, so personally for me, pictures work better. So what has the government said? So in July, there are no changes. No changes to furlough. So the furlough scheme still covers 80% up to a cap of £2,500. That's fine. In August, while the furlough payments still remain the same, the employer is now not going to be able to claim the grant that they have been receiving for employers' national insurance contributions and pensions of that cost of the furlough claim. So for organisations where, I'm thinking particularly hospitality type industries, where probably about 98% of your workforce is furloughed, you're going to have to start paying some costs from August. The question that you need to start asking yourself as a business, can you afford that cost? Do you have cash to pay that money? If we then move through into September and October, this is where employees then start to make a contribution towards the cost of the furlough payments. So the government have said that in September and October, employees will still receive 80% of their salary, capped up to £2,500. It's just who pays for it is changing. Rather than the government covering 80%, they're now going to cover 70%, with the employer taking on 10% of the cost burden. So it's not 70% of the wage, it's not 10% of the wage. It's if you take that 2,500 and you break it down 70-10, it's 7/8 of 2,500, which is how you get this HMRC cap of 2,187.5. Then if you go into October, again, the balance is starting to shift even more, with employers covering, the government covering 60% and employers covering 20%. This 10 and 20% are not optional. So you still create your furlough claim in the same way. You would still cost it and calculate it in the same way. It's just the amount of money you can claim is going to change, because don't forget, you're still paying it through payroll. You then go and claim some money from the government. And nowhere has any announcement said so far that these 10 and 20% employer contributions are going to be discretionary. So we must think that they are mandatory, particularly if you're starting to try and do wage cost calculations. Assume you're going to be paying more than you actually might need to. So that starts to get us into a level of complexity. So if we can move forward on a slide, and let's take September as an example. So I am reflecting and using the Chancellor's words of an employee could work 2 days and be furloughed for 3 days. So if we look at September, there are 22 working days, I think, at the bottom of the slide. Purple indicates a day when an employee is on furlough, and the blue colour indicates a day that is a normal working day. The illustration of this is for you to then think about how are you going to make sure you are paying correctly, because on here you are paying one set of monies for the furlough days with one set of calculations that sit behind it. And we already know that the government has calculated a day's furlough pay differently compared to how employers calculate a normal working day's pay. And that's where you're going to have to start having, I would say, incredibly good records about who is doing what on each day and what rate of pay that attracts. And I would start thinking about this now, because we don't want to get to September. You think you've got plans in place and then something comes out in terms of a calculation. We are hoping that the calculations are also confirmed in June, when the next set of guidance comes as well. So that brings through some big organisational questions. So if we could move forward a slide, and this is just where I will leave things for now to open up for questions. So the key things to think about is, if you need to furlough employees who have not yet been furloughed, you need to start their furlough period on the 10th of June at the latest, because they need to be part of this claim that goes up to the 30th of June. This is what they mean by new entrants. A new entrant is somebody who has not yet been furloughed. Then, as I said earlier, when you think about August and payments, can you afford the employer's national insurance contributions and pensions? And if you can't, back to Andrew's earlier point, do you need to start thinking about consulting? If you can't afford your wage bill, what are the consequences for you as a business? And does that take you into some kind of consultation territory? If we think about bringing people back and standing up the workforce, you're going to have to start thinking about who are you going to determine to be brought back, and for how long, and for why. You might need to start thinking about what your working patterns look like, and you're really going to have to start thinking about how you ensure the accuracy of your pay calculations. So I'm sure payroll teams who have had a lot to deal with already to work out furlough in general are now going to have another set of things to work about when we start introducing flexible furlough. So I think for now, that's where I'll end what I'm talking about, but these are certainly the questions that I'm helping clients figure out and work out, and how to start thinking things through. So I think at this point, I'm handing back to Katie, I'm assuming.
Yes. Oh, the sound seems to be working fine. Just going to say that I had to log out and in again. I've lost all the questions. They've been texted to me. It's all super fun and games. Can I ask everybody to unmute themselves, and we will go to questions. And the first thing I'm going to ask, I know Andrew and Tom, you've both covered it, but just to get clarity, because so many people have asked it on the Q&A and also sent us the question in advance. If somebody has been furloughed already and they're not furloughed on the 10th of June, they come back into work, or they're coming back towards the end of June, are they eligible if they are physically still working? I know you've both said that, but just to get for clarity. Andrew, you first.
Yeah, absolutely. The way the fact sheet and the guides we've seen so far is written, it clearly suggests that anybody who has been furloughed at some point during the life of the scheme can be placed on flexible furlough, yes.
And I would absolutely agree. That's exactly what it says. It's my green category of people on my slides.
Okay, we'll take that's two people who interpret it that way, so we'll hopefully assume that's right. We had a question about collective consultation, and can you consult with employees while they're furloughed, or do you have to bring them off furlough in order to consult with them? Andrew, can I put that to you first from a legal perspective?
Yeah, certainly. I think there's nothing from a legal perspective that prevents you from consulting with people who are otherwise furloughed and not working, or, you know, in the future back on flexible furlough. So I think yes is the answer. You can consult with people who are furloughed.
And I don't know if Tom or Ben, either of you, have got any advice on how to do all that stuff over Zoom or whatever other tools are available, how to kind of make it as kind of respectful as possible.
It's a difficult area. I think, you know, for so long we have been so used to consulting in a particular way. I think particularly for organisations who don't have employee staff representative groups already, is another level of complexity. And we've been supporting lots of clients through this process already. So yes, via Zoom, you need to find the best way that you can engage with your workforce to go through staff consultation and selection of reps, but it can be done. And as Andrew says, you don't need to bring people back off furlough and pay them kind of normal working rates in order for them to become staff representatives or for you to consult.
Thank you. A question around holidays and flexi furlough. I don't know if we'll be able to answer this yet. Under the new scheme from 1st of July, will HMRC fund 80% of the holiday pay if an employee works 2 days and takes 3 days holiday, as an example? Who wants to weigh in on that?
I don't mind going first, because I think the answer is we don't know. Obviously, under the old scheme, you were furloughed, but you could take annual leave, and the employer just had to pay for the top up. We don't know. The guidance simply isn't there. It could be that those holiday days are counted as you are in work, so the employer has to pay all of the cost. My guess, if I'm a betting person, that's where I would go if I was the government, because it's less money for the government to pay out. But quite simply, we just need to wait for the updated guidance to come through.
I think that might be the answer for a few of these. Another question about, actually I think this came in advance, if you're, oh no, not related to redundancy, but resignation. So if you have somebody who's resigned during furlough, what do you pay their notice pay at? Is that at 100%, or if they're only on 80% at the time, what are you kind of obliged to pay them? What should you pay them, Andrew?
If their notice period is statutory notice only, then any notice pay should be at 100%. So you would be funding right now an additional 20% yourself, and that obviously will rise as the flexible furlough scheme kicks in. If somebody's notice period is more generous than statutory notice, then you can pay them a reduced rate if that's been agreed. So in the case of furlough, that may well be at 80% for the moment. So it all turns on how much notice they are entitled to, excuse me, of dismissal. And that governs the amount of pay that they are entitled to during the notice period.
Thank you. It's quite a specific one here about somebody who's had different answers from HMRC regarding past overtime payments. In the end, we made a decision not to include the past overtime into the furlough calculations, but now the directive stating that past overtime should have been included. What should we do now? And they add that they haven't had any questions from employees about it. I assume just want to do the right thing.
Ultimately, I suppose those employees may have a breach of contract claim if their overtime pay was due to be paid and wasn't. So I think it would be worthwhile trying to head that off by dealing with the issue proactively. The problem is, of course, if you're paying in a new pay period, it may take you well over the threshold that you can claim reimbursement for. So it may end up costing you, but certainly the guidance as far back as I can remember did say that contractual overtime for overtime previously worked could be reclaimed under the scheme. So I think you are obligated really to pay that overtime pay where it's due.
Just to add to that, I think that there was, to your point, Andrew, there was a period of time where it was not clear, and that was probably the first couple of weeks. And HMRC did not do themselves any favours because they were putting out different answers to the same question. which has confused a lot of people. So it almost got down to the point of it depended who you got answering the question, and if you kept asking the same question, you could get the answer that you wanted. I think the difficulty with this, to your point, it's not clear whether you could go back in time and claim that money now, because HMRC have updated their guidance. But at the same time, do you want your employees to be at a detriment? What I've been advising clients on is you have to have documented the advice that you had at the time from HMRC to base your decision on. So if you had advice from HMRC in a tweet or whatever that said don't include it, then that's your backbone of your argument. Yes, as things then change, you can then start including overtime, but you might then want to get back on the phone with HMRC to work out how you can fold previous overtime back in, because you have made the right decision based on the information that you had at the time. So it's a tricky one, and HMRC really haven't helped themselves with some of these questions.
Thank you. Ben, one for you. What are the legalities of asking staff to return and work in the office? Should we still be asking people to work from home if they can?
Yeah, I mean, I think CIPD's been sort of highlighting sort of three key sort of principles around thinking about whether people should come back to work, the workplace. One is, and the first one is, is it essential? And so obviously, if people can work from home, then they need to continue to work from home, unless there's a very, very good reason for them not doing so. The second one is obviously, is it safe? And so that, obviously thinking about can you make workplaces safe through things like the use of personal protective equipment, social distancing, changes to the workspace, staggered shifts, etc. And then the third principle around, is it mutually agreed? And so I think that's key to being at the heart of the risk assessment, which is core to a safe and legally compliant return to the workplace, making sure that when you're doing risk assessments and consulting with staff, you're taking into account not just people's physical health and safety in terms of protection from any risk of infection, but also their mental health and well-being and their levels of anxiety or stress, which might be connected to a whole range of issues. So I think it's bearing in mind those principles and recognizing that this pandemic affects people in very different ways depending on their sector, the type of job they do, their family or household circumstances, and their personal characteristics. So it's complex, it's difficult, but I think if you keep those sort of three key principles in mind, it's a good framework to help you make the right decisions and ensure that people do make safe and mutually agreed returns to the workplace.
Thank you. Got some questions around maternity leave. Somebody's asked, if we have employees returning from maternity leave after the 10th of June and before October, how would you recommend we approach this scenario, as a flexible furlough scheme could be really relevant to this group on their return? Tom, have you got any advice on how we can think about that?
Yeah, I think unfortunately this might be a group that is kind of left by the wayside in a way. If we look at what the detail says, if those individuals who are coming back from, if I broaden it from just maternity to any kind of statutory leave, adoption, paternity, whatever, if they've not been part of a furlough claim through the qualification period, then you're not going to be able to put them on the flexible furlough scheme. I think the government are starting to stand up a little bit more to say, we know that not everybody is covered, and actually we know that we can't cover everybody in every single eventuality. Unless some more guidance comes through that says, as an exception, you could do X, based on what the current guidance says, is I think you won't be able to put them on a flexible furlough scheme.
Andrew, any thoughts on that?
Yeah, I think that's right. I think this 10th of June deadline effectively causes all sorts of issues there and really prevents that group, if they're not due back before the 10th of June, from being considered for flexible furlough. But what you might well consider would be other flexible arrangements in the usual way for people returning not only from maternity leave, but perhaps with health conditions of their own, or maybe they are living, sharing accommodation with people with particular health conditions. So I think there'll be all sorts of groups of employees in particular situations that you will need to talk to and try to reach some kind of accommodation with where appropriate.
And on the subject of this is paternity pay rather than maternity, can someone still take paternity leave while on furlough, or do they commence it on return to work? Andrew?
For me, I don't think you can do both together. So if you're on paternity leave, you can't be on furlough and vice versa.
Yeah,
I agree with that.
Yeah. We've had a question: if you've got somebody who is currently in their probation period and they're on furlough, can you dismiss them if their performance was poor before they were furloughed? And I assume you says they were aware that they needed to improve, so they're probably on some sort of performance improvement plan. Where do we stand on that?
Well, it's almost certainly the case that, well, it will be the case that anybody in the early part of their employment will be well under 2 years, so they won't qualify for unfair dismissal rights. So the only risk to really to be alive to would be the risk of a discrimination claim. So you would assess the situation for those risks in the usual way, but subject to them either not being there or being fairly negligible, then you're free to handle that situation, manage that situation as you see fit, obviously observing the contract and paying any notice paid due.
So I think to add to that, obviously we have the legal basis of what you can and can't do, and I'm seeing a lot more conversations that kind of centre around, well, that employee doesn't have 2 years service, so we can just get rid of them. I think this is going to be a really big test for employers, particularly in terms of employee engagement. And while you may be able to do those things legally, the question you need to ask yourself is, should you? So let's take the example of somebody who is on a performance improvement plan. The advice I'm giving to employers, if you can, pause it. Wait till they come back, because actually that's the fair and right thing to do. They're not on furlough by their own, they didn't decide. It was an agreement with you. You've given them a chance to actually improve their performance. So it's a weird world that we're getting into it, and actually the tone that is starting to come through very much is, they're under 2 years, just get rid of them. As I say, while we have that legal framework, you've got to think about the damage that might do to your overall employee experience, which is going to have a lot longer, far-reaching implications for you as a business longer term.
Do you have any thoughts?
So I was just going to jump back in there and say, I mean, I absolutely agree there with Tom. And of course, in the context of particularly disability, it may well be that performance has been affected by a condition or an illness. And maybe that's not come to the fore in the short period someone's been employed, or maybe, you want to give yourselves time to consider reasonable adjustments to see how they work. So I think the two answers there tied together, actually, that it's always good practice to give people a chance to improve in case there is that underlying discrimination element. Thank
you. I've had a few questions which I think the answer is probably going to be we don't know, but I'm going to ask them anyway. A few people asking, is it going to be a minimum of 3 weeks? Do we have any reason to think that it might not be? Andrew, you said you thought probably just carry on as a 3 week.
No reason to think not, but we await the guidance. But yeah, no reason to think not at this stage.
And then the other questions are around kind of how flexible furlough can be. So does it have to be in full days? Could it be done in hours? So working half days? Somebody work 3 days 1 week and no days another week?
Well, so the Chancellor in his announcement said, I want employers to have the maximum possible flexibility. I think everybody's guess is as good as anybody else's in terms of what that actually means, what it translates to, and actually what is practical. So you could, even if it comes out as effectively saying you can do whatever you want, you could furlough for every third day in a blue moon and not do anything else. From a business operations perspective, that level of flexibility is great, but you actually have to think about how you're going to utilize it for you to actually sustain your business operations and to reduce and avoid a level of complexity. because otherwise all you're going to do is have a million questions coming from your employee base constantly. So think it through before you kind of go, Joe Blogs is going to work on the 1st, 3rd, 9th, 15th day of the month. Just start thinking it through.
I think the only thing I'd add as well is just we're thinking ahead to the end of October. That this scheme will end complete then, and so thinking about how you gradually bring different individuals, different groups of employees back in a way which will mean that you're prepared for the complete removal of the job retention scheme from 1st of November. So I think that needs to be in the background, what a sort of strategy around getting people back into as much sort of normal working as possible during the course of the next few months.
Thank you. And on that topic of kind of flexible furlough again, how will it work? Do we have any idea how it might work for those with no set hours, so perhaps those on 0 hours contracts?
No, I don't think there's any clarity yet on the exact operation of it. Hopefully that level of detail will come out in the next set of guidance.
Yeah, thank you. Somebody's asked about they're considering furloughing for a group of shielding individuals who are 70 plus or clinically vulnerable, but because they can't return to operating because it's a high risk environment. At the moment it's covered by a kind of COVID expenses scheme from the NHS. Some of these people, the over 70s, aren't that happy about being away from work or the idea of being away from work. What happens if they refuse furlough and they don't reach an agreement? Andrew, any advice on that?
I think if you had genuine concerns about maintaining their safety at work, then you would need to come to some arrangement that dealt with that, either by adding extra protection in the workplace, or setting up a working at home arrangement, or working at different hours. But you would need to head off that risk. Ultimately, I suppose, if you had real concerns about maintaining health and safety, you would place somebody on medical suspension, and absent anything in the contract, and most contracts are silent on it, that would need to be paid. But I think the first step is always to talk to the employee, address the concerns that they have, or try to, and reach some mutually agreeable compromise.
Ben or Tom, any kind of people management advice on if somebody's refusing to be furloughed for their own safety?
So I think, so Ben, you go.
I was just saying, I think, if you can put in, practical steps to, as far as possible, support their safety, and they are comfortable with that, then in some workplaces, in some contexts, that might be possible. And I think one of the reasons why this challenge is so difficult is, the level of risk will vary massively across sector, job type, and also the type of sort of underlying health condition that individuals have. So it's very difficult to have a sort of a sort of yes/no answer. I think it's very much down to the individual, the context, and what type of job and sector that they're working in.
So can I just clarify, Katie, is the question centred on the employee wants to come back, but the employer does not want them to?
Yeah.
Yeah, because I think...
they're shielding and they
right.
want to come back, yeah.
The thing from Ben and Andrew, what I've heard from Ben and Andrew is almost, it's more the other way around. The employer wants them back, but the employee doesn't want to come back. And that just could be the way that I've heard it, but I just wanted to make sure for the audience that we've clarified. Again, I agree with the points that both have made, which is this is about talking to the individual. But I think you have to set out your concerns. So why do you not want them to come back? Why do you want them to remain on furlough? Because some employers will take it on a basis of going, I'm worried about the risk that the employee, I might get sued by the employee, because they might pick up COVID in my workplace. You'll have that school of thought. You'll have the other school of thought, which is, as the employee, I know better than my employer. I know better than my employees. The right thing for my employees is to stay at home. And for some employees, it's not. It's really not. So, you know, we've skirted around the mental health issues of people being at home, being physically distant from people and not having that interaction. So some people will want to be surrounded by people for their mental health. So as an employee, you've now got to really start balancing mental and physical health. And if somebody wants to come back into the workplace and you are already allowing others in, so you have taken reasonable precautions to bring back the vast majority of your workforce, at some point you've got to let the employee make that decision and have the conversation with them. But don't assume that people want to stay on furlough. And, you know, in this case, this is clear that the employee wants to come back. But as the employee, don't assume that you know better than your employees. So have a conversation with them.
Thank you. I'll just, one more quick one. Is redundancy pay calculated at furlough rate or full 100% of pay, Andrew? We're talking
No,
about
yeah, absolutely. No, on the basis of normal salary is the answer. So you would disregard any reductions for the furlough arrangement.
Right, I'm going to have to leave it there because we are almost out of time. I'm sorry that I haven't got to ask all of your questions. I'm sorry I had to leave halfway through to fix my sound, which meant I might have lost some, but we've done our best, and I think we've answered quite a lot of them there. The webinar and slides are going to be available on demand from this afternoon, so feel free to watch it again. You'll be able to download the slides as well. You can also sign up for future webinars on the CIPD website. And this Friday, we're going to be exploring the impact of COVID-19 on the labour market and on hiring. The week after, we won't have any webinars because we're doing Festival of Work. So as I said, free for CIPD members. Do remember to sign up if you haven't done so already. And then I am pretty sure that once the guidance comes out on the 12th of June, we will be reconvening to go through that in wonderful granular detail at some point afterwards. So please do look out for an announcement about that. Thank you so much to Tom and to Ben and to Andrew for taking the time out to share your expertise with us this afternoon. And finally, just a final reminder about our wellbeing helpline for members in the UK and Ireland. And you can see details about that on your screen now, how to access it. So that's it from us for now. Thanks so much for watching, and we will see you next time. Goodbye.